Hello, good evening, Ms.Shilpi Jha. How are you? Hope you can hear us.
Yeah, hi. Can you hear me?
Yes, we can. It's very clear. Good evening, and thank you very much for accepting our invitation. So this is going to be the sixth session of the Emerging Scholars Research Program. So this program has been launched to give undergraduates a proper research experience. So they go through the first session, they learn about research, starting from research ethics till technology transfer and IP management, and then they'll be allocated to different various research groups that we have. So they can start their own research while they are in the second year. So by the time they graduate, our objective is for them to have some kind of publications under their name. So welcome to Sri Lanka Technology Campus, and thank you very much again for accepting the invitation. I will introduce Ms.Shilpi Jha. We are recording this talk, and also we'll be publishing this in our LinkedIn account and social media accounts as well, so that more students will have the opportunity to listen to the talk. So Ms. Shilpi Jha is a senior commercial specialist and IP policy advisor for South Asia at the US Patent and Trademark Office, USPTO, located in New Delhi, India. And she is responsible for managing and advising on intellectual property matters related to India and South Asian countries, playing a vital role in promoting strong IP protection, enforcement standards, and enhancing cooperation between the United States and the South Asian governments in IP issues. With over 14 years of experience in legal practice, business development, and public policy, Ms. Shilpi has worked extensively in IP policy, capacity building, anti-counterfeiting, and anti-piracy efforts at both national and international levels. Prior to joining USPTO, she served as Deputy Director at the Confederation of Indian Industry for 8 years, where she drafted policy papers and represented the industry in government discussions on IP matters. Ms. Shilpi has made significant contributions to anti-counterfeiting and anti-piracy initiatives in India, and has provided expert advice and litigation support on IP and civil cases. She holds a degree of law from Delhi University. In addition, she has done her degree course on intellectual property rights from World Intellectual Property Office, WIPO, Geneva. She is also a postgraduate in statistics from Hindu College, Delhi University. So, Ms. Shilpi Jha, over to you.
I thank you for that introduction. And I will, at the outset, I would like to thank the university for thinking about this important topic for the research student and deciding to have it, and also for inviting me as a expert on intellectual property rights. So intellectual property rights is something which nobody can be expert, frankly, because it's evolving every day. The concept, the idea, especially with artificial intelligence coming into place, things are changing every day. But thank you for inviting, because this is a very important topic. Before I start my presentation, I'd also like to let the group know that we are also joined by our senior commercial officer, Miss Natalie, who joined from Delhi office. She just wanted to understand this program, how it happens. So she is online, just for everybody's, information.
Hi,
Natalie, maybe you can say us hi.
Sure, Shilpi. I'm glad to see you on this program and see students interested in this topic. Just here to learn, although I also have a legal background, so this is of interest. And we work very closely with Shilpi and her team when advising US companies doing business in India and vice versa. We work with Indian companies, Sri Lankan companies looking to invest in the US, and there are many hurdles to navigate when it comes to IPR. So you're in good hands with Shilpi.
Thank you. Thank you very much, Ms. Natalie. It's really nice having you here in this program. And in fact, I'm also a graduate from a US university. I did my PhD at UConn, University of Connecticut. So really nice having you here.
We just had the governor from Connecticut here last week.
Okay, interesting. Thanks.
So Dean, you like me to go ahead with the presentation, or you want me to wait, or how you want to go about it?
Yes, you can start with the presentation, Ms. Shilpi.
Okay, so I'll share my screen. Let me know if it is visible to all of you.
It's visible, yeah.
Okay, so I'll go off the camera because that way presentation quality will be better. So first of all, as I said, thank you for inviting me to give presentation to an important group of audience, which is researchers, because nowadays with the kind of innovation and globalization which is happening across world, I think researchers have the biggest role to play when it comes to development of country in all aspect, whether it's the IP ecosystem, innovation ecosystem. Every country needs a good team of researchers, and what better way to have a researcher who is a well-informed researcher when it comes to intellectual property rights, because IP obviously is one of the most important aspect of any innovation, invention, whatever you do in when it comes to technology. So on that note, I'll start my presentation, and the presentation, how I have thought about running the presentation is that I'll briefly talk about what we do as a USPTO here in New Delhi office, and about briefly about the fundamentals of intellectual property rights, which many of you might not be knowing in detail, like the thin line of difference between different categories of IP. And then what is the benefit, because many of the times, even if you know what is intellectual property rights, you don't know how to go about it, how to reap the benefit out of it. And then finally, I'll go into what is future in IP. It will be how you can use your protected IP for commercialization, and also touch a little bit upon the what could be a future for students like researchers once they graduate or they have a degree in intellectual property rights. So that's how I have planning to go about. And all of you, those who have questions, feel free to put it in chat or whatever way the organizer like to run it. Uh, on that short note, first of all, it's a very, many a times when we travel across South Asia, there is always a question about what USPTO is doing in New Delhi office. So I'll briefly touch upon that. What is USPTO? I'm sure all of you know that every country has a organization which takes care about protecting and registering intellectual property rights like trademark, copyright, patent. So USPTO is the federal agency that grants US patent, and it has headquartered in Washington, DC. And this organization agency is was framed with the mission to foster innovation and competitiveness and economic growth domestically as well as abroad through the IP filing and registration. And the office that I belong to, which we call at USPTO Attaché office, we call it an Attaché office because it is unlike a USPTO headquarters, which is there in Washington, which deals with the filing of IP where you can apply for your patent, trademark. Attaché office, which is in different part of the world, is an extension office of USPTO, where we primarily, help to improve IP system internationally, carry out US objective to promote improvement in patent, trademark, copyright, and also promote high standard of IP protection and enforcement with the host country. Like as Sir Dean Sir was talking about my profile, I cover all of South Asian country. So my job sitting here in New Delhi office is to see that most of all the country in my domain has a better and a good IP standard of IP protection. More so because now with the globalization and the e-commerce, the way it is expanding, it is important that even if it's a small startup sitting in small part of village of Sri Lanka or Nepal or India, they are aware about the importance of IP and how they can, protect it to get the best outcome of their innovation that they have generated over a period or with their effort. Also, the most important pillar of my job profile is to assist business in protecting and enforcing IP right. So, for example, if there is a US company who want to set up their office or have a licensing agreement with a company in Sri Lanka, so I help them advise to see what are the best mechanism, who is the organization they should collaborate with, and what are the areas they should be careful about. So this is what our office, which is here in New Delhi, works about. And also, as I mentioned, Nathalie, who is our, deputy senior commercial officer, we work in tandem with FCS, which is Foreign Commercial Service. So this office, IP attaché offices, comes under FCS office in the region. So these are the threefold activities we do in the region, which is policy advocacy. We work and improvise upon the existing policy of South Asian country, work with the government very closely. Like in most of the country, we have a MOU with the local government. Like we have a MOU with India, we have with MOU with Bhutan government, we have a MOU with Nepal. Right now, we are working to have a MOU with Pakistan. We work very closely with all country, and we work very closely with NIPO in Sri Lanka, which is National Intellectual Property, on policy issues. For example, NIPO in 2021 they signed mandatory protocols, so we have been working with them to see how they can change their trademark policy to have better benefit for the uh, filers from Sri Lanka in different part of the world. And then capacity building, this is one of the kind of capacity building we do. So capacity building is to train and educate foreign officials on IP laws, on US IP laws, as well as across the region IP law, and also for the enforcement official. For example, we work closely with the custom, police, judiciary to train them on the best practices across worldwide on intellectual property rights, because not all countries, all judiciaries are aware about the intellectual practices all over. So we do those things under our capacity building program. And then the third pillar, which is due diligence on behalf of US companies. So it's not always on behalf of US companies. Sometimes we also help the local companies. Like, for example, there is a Sri Lankan company. Like, let's take example of Sri Lanka. Last year, Ceylon tea had some GI issue in US. Like, they wanted to understand how they can apply for geographical indication in US. So we help them to, find all process and connecting them with the USPTO headquarters. And finally, now they have registered GI in US for all their. I think they have 7 or 9 varieties of tea in Sri Lanka. So that also we do. It's like, both ways. Due diligence we do on both ways. And like we have USPTO South Asia office in New Delhi, which covers all of South Asian countries. Similarly, we have 14 attaché office all over the world, which have a regional responsibility. Like a country, like an attaché office in Europe has multiple country under their portfolio. Similarly, the one office in Southeast Asia, they have multiple country under their portfolio. So in total, right now we have 14 country, offices all across world. And we, from the USPTO side, we don't only work standalone as USPTO, but because as you all will understand and appreciate that IP per se is just not limited to one person. It is across sector, across region. Even police needs to know, judiciary needs to know, consumer needs to know, university needs to know about IP. So under US, we work with different agencies. And we also, try to advocate for all our host country, all our country under our region to have a good coordination mechanism for IP. Because sitting in university, for example, you might be having an IP policy in place, but you don't know what is the overall policy of government of Sri Lanka on what kind of IP policy a university should have. So that kind of collaboration with different interagency help you to understand and to have a better implementation plan, which is more effective. So that was all about our office in New Delhi. And do you have any question on that front, or
We are all set.
you want me to stop here?
We are fine, Ms. Shilpi. Please go ahead.
Okay. So, and I'm sure all of you would know that IP has why IP has been being spoken so much nowadays is because uh, it is all about encouraging invention and protecting invention and promoting commercialization and application. We all know that how what we how we kind of look in front into the world is how we uh, dress up. If you want to look nice, or if you want to show that we are well learned and well spoken, then we need to have some kind of dressing mechanism, or we have to be have from a good university. Similarly, IP, intellectual property, is a kind of property which help you to project yourself as a good product to the market, and that's why IP becomes very important. And why you should have an IP strategy as a business strategy? Because it is attractive to investors and buyers. If you take an example, for example, you take Ceylon tea, there might be a tea coming from the same field or same agriculture province in Sri Lanka. But if tea comes without a proper packaging, or even with a packaging which people are not aware of, and if you have a Ceylon tea in another hand, as a customer, you'll be more attracted to a brand which is Ceylon tea than a tea packaging which has no brand. Because a brand attracts the investor. Even suppose, for example, I'm a big, agency who wants to buy uh, tea packets for my country in India or in some other part of the world. If I'm traveling to Sri Lanka, I will not buy a tea which comes from the same agricultural land, which is same for the Ceylon tea, because I would buy Ceylon tea because I know Ceylon tea as a brand. Though the both the taste leaves of the tea would taste same, but brand has a value. So IP is important to know and to have a filing because it attract to investors and buyers. And at the same time, if you have done some kind of innovation and invention, it is important to have your IP protected, because then you are making the world know that you have right on that IP which you have invented, and protecting it from getting copied or counterfeited by some other person, because you're letting the world know that you have a registered right on your invention. And as I said, it encourages the leveraging power. When I say leveraging power, I'll share a very interesting example. So there is a small state in India called Jharkhand. Many of you might be knowing, where there was this lady who used to make pickle using mushroom, which was effective for the diabetic patient. And she came to one of our conference where she learned about intellectual property. And then she realized that it is important for her to have a brand name for her pickle and good packaging material to package it and to sell in the market. So once after, having a session with us, she went back and she had a trademark, which is one form of IP, which I'll be talking soon, and got it registered with the IP office. And then what she did, because sitting in a small village, she couldn't have a market for herself. She collaborated with what you call a marketing chain called Big Bazaar, to see that her product gets sold through their departmental store with her branding on that bottle. And you won't believe, after few months and few years, the state government rewarded her for maximum sale of a pickle, which was effective for diabetic patient. So what I'm saying is that intellectual property, once you register it, you get a leveraging power. So even if you don't have strength, caliber, and money to invest in your product, but once you have a good leveraging power by registering your IP, you can sell it or license it to some partners who can then market it, and you can reap the benefit in the form of royalty cost or otherwise as a profit from whatever is being sold by the other person with whom you have license or any kind of agreement. And of course, property right that adds value and it gives you a global image. I just gave you an example of Ceylon tea. So if I have to buy tea from Sri Lanka because Sri Lanka is famous for tea, I would rather, as an American company or an Indian company, I would go to buy a Ceylon tea rather than the other tea which has no branding or packaging in place. So that is the crux of why IP is important. Now, I'll go in detail of the IP. So, before registering your IP or identifying your IP, it is important to understand that there are four stages for intellectual property. One, identify your IP. It is very important that even, for example, you're a research student, when you're drafting a paper or you're coming out with the publication, it is important to understand what is your IP in that. Is the paper that you have developed is whole your IP, or is there is some part of it which you have taken from others write-ups and you have tried to club and bring it as your own product? So identifying whether your paper is ready for registering as a copyright, trademark, or patent is very important, and then protecting it under the IP. Sometimes what happens that it's people don't identify in a right way. Suppose you are writing a paper on copyright and artificial intelligence, and you want to register that book without realizing that copyright and artificial intelligence is a very generic name. You go and apply for copyright filing. So if it is a common name which is copied or written by somebody else, it won't be able to get the protection as you are trying to. So identifying your right kind of IP, then going for protection is the next step. And then it is not only important to register your IP, because you may register your IP, but IP is not for eternity. It is for a time limit. Like for patent, it is there for 20 years. Trademark is there for 10 years. Then you have to renew it. So it is important that once you register your IP, you have to identify strategies to work around it. Like what is the like I spoke about this lady who she first had a developed a trademark, then she had a proper branding in place, like branding her bottle, labeling her bottle, and then she started collaborating with the funding agencies or the department store. So that is a kind of strategy that she developed, and that led to commercialization of the IP. So IP is just not identifying IP. Like suppose I tomorrow write a paper, I'm very happy that, oh, this is my original thought process. This is my IP. That is not enough. You have to identify that, okay, this is my paper. So let's see under what category IP it falls. So it is, if it is a paper written by me, it falls under a concept of IP called copyright. So that way you have to identify whenever you are doing anything under your innovation and your ideas. This I've already covered. Just a sec. Oh, why it's coming again. Sorry. So while I'm going to, I don't know why it is getting repetitive. Okay. So now I'll come to the main point. What is the different categories of IP? So, when you think about IP, generally as a person, as a human being, we think, okay, we know everything about IP. It is patent. But people fail to identify that IP also have a different categories. For example, I'm sure many of you have heard about speakers connecting intellectual property right with the property right. We connect it because IP is just like a property right. Under the property, when you buy a land, there are different type of lands. There are lands for residential purposes, lands for commercial purposes, land for agriculture practices purposes, and all these different categories of land has to be registered with different department of government departments under different categories. Similarly, intellectual property right also there are different categories of IP rights. So what are those categories? Patent, copyright, trade secret, trademark, and there are two more called geographical indication, integrated circuit chips, Those are there in few countries and they are not there in some of the country. Not every country have protection for integrated chip, but many of the countries have. But majorly there are 5 categories of IP, which all of you should know as a research student. One is patent, second one is copyright, third one is trademark, fourth is trade secret, and then we also have a concept called design patent. In some countries there is a design law, separate design law. In US we have design patent. There are two types of patent in US: utility patent and design patent. So it is very important to now differentiate between these categories of IP. So what can be covered under patent? Patent is primarily for a product or a process which qualifies 3 steps, which is that it should be an inventive, innovative product which was not in prior existence, and it should have an industrial application, and it should be non-obvious. Non-obvious means that it should not be, when you come out with the product or a process, it should not be obviously known to a person. So suppose if you come out with a uh, pen in front of me. So I'll say, what is so new about it? This has been in existence. So this is an obvious patent which is already in existence. So for qualifying to file as a patent, you have to, first confirm that your product or process is new to the world. It is an invention. It is not something which was known in the world before. It is new thing. And then it has to have some kind of industrial application. So if any of these, points are missing in your product or process, then it won't fall under the patent protection. So in that case, you can't apply for the patent application under the patent IP office. Here I have given an example in this slide is like chemical fertilizer, process of manipulating genetic trait in mice. All these are example of innovative ideas which was not in existence before, which was not in prior use. It is not obvious to us because it was not in existence before. And for patent, generally every country, most of the country give protection for 20 years from the day you apply, you get your patent registered with the local IP office. And after 20 years, the patent gets to the public domain. That means that once it completes 20 years, anybody can, copy your technology or your process, whatever you had invented 20 years back. And it will be free for everybody. It will be in a open source. Anybody can use it. Few countries have it for 17 years, some have 15 years, but most of the countries have for 20 years because, as you might understand, that intellectual property is an international law. Unlike criminal law, property law, which can be specific to a country, IP needs to be internationally seen. Every law that is made locally in your country has to have an international standard, because IP is just not limited to your own country. It is across world. Like any product which is invented or created in Sri Lanka will be traveling to some other part of the world. So it is advised that IP law has to have an international best standard, which people tend to follow WIPO standard, and they have it from culture, have their own cultural input also in their policy. So that's about the patent in brief. And also, before I go to move to the another category of IP, it is important to understand for all of you as a research student that IP is territorial in nature, meaning thereby that suppose if you have created a product or invention which you have patented in your country. So if you want to get protection in India, in US, or in Nepal, sitting in Sri Lanka, you have to apply for patent in those country also. So if you're applying in Sri Lanka, that doesn't mean you are getting a protection in rest of the part of the world. To get protection in other part of the world, you have to apply in those country also. And to because many of you would like to know, so I'll briefly touch upon this also. That to make lives people's life convenient, there is a concept called Patent Cooperation Treaty, which is run by WIPO. All these international treaties are run by WIPO, under which those countries who have signed that PCT agreement, those country members, like if you are in Sri Lanka and Sri Lanka is a member to PCT, then sitting in Sri Lanka, You can apply in US also, because under the PCT application, you can tick mark those country where you want to apply along with Sri Lanka. So that way, it is helpful that you don't need to travel to US to file in US. Under PCT, you can apply in the countries, those who are member of PCT countries. So not in all countries, but only those members who are part of the PCT agreement. So there are two things that I just mentioned, which is important for all of you to remember. One, that IP rights are territorial in nature, meaning thereby that if you have registered in your country, then you have protection only in your country. To get protection in a different part of the world, you need to apply in the IP office of those country also. Like if you want to get protection in India, you need to apply in the IP office, Indian IP office. Or you need to apply, if it is patent, you need to apply through PCT application. That was one. And then there is a concept of design patent. So design patent, as I said, in the US we have design patent, but in most of the South Asian country, it is design law. Like you can get registration of a design for 3D or 2D model of any unique shape, or it's called ornamental features under the Design Act. So it is not called patent in South Asian country. It is just like a trademark or a copyright. But under the US law, it is called design patent, because for design, you have to apply under the Patent Act. And again, designed patent is for 15 years. In most of the South Asian country also, it is for 15. Design registration is for 15 years. But for registering a design, there are two things you have to qualify for. One, it needs to be a new design, and it should be representable in 2D or 3D models. And the third, which is very important for researchers, is copyright law. Copyright law, which is right to register your copies of your work that you do. It could be, a presentation, it can be a research work, anything that you do, which is your original work and which can be put in a tangible form, can be registered under copyright. Anything that you can think about. But it has to qualify two steps. One, it needs to be original. Second, it needs to be tangible form. Tangible form means that suppose I am writing an article on some artificial intelligence in my mind. Okay, this is that is not a copyrightable material. It has to be in some tangible form. I need to have put it in a presentation form, in a book form, in a paper writer, in a CD form. It has to have in some kind of tangible form. And then copyright can be a file for anything. It can be book. It can be a small thing like a photo, which you think is new, your own creation. It can be music, which you think you have created your own lyrics or on your own song. It can be graphic image. It can be film, but as in anything under the sun, which is original, which can be put in a tangible form, can be registered under copyright. So this is the beauty about copyright. And researchers' book and everything has to be registered under copyright. And generally, most of the country gives a right to register copyright for 70 years till the life of the author. Meaning, suppose if I have written a book, I can file a copyright application in the IP office, and I'll get right till 70 years. And after my death, it will go to my heirs, and then once that is over, it goes to the public domain. So, but this here also the number of years varies from country to country. I think in Sri Lanka it is 60 years. You can confirm it once. So this is copyright, and under copyright there is a very interesting concept about fair use. What is considered fair use, which all researchers want to know. So I'll go to that and later in the slide when I'm done with the basics of fundamental of IPL. The next very important concept is trade secret, which is not available in most of the countries. But in Sri Lanka, which is very interesting, the IP law of Sri Lanka do mention about trade secret. Though there is no standalone trade secret law, but there is a mention that trade secret is an important concept and that should be taken care of. But trade secret law, unlike other IP law, is very interesting because for patent, for copyright, for trademark, you have to apply to IP office to get the protection. But for trade secret, You don't need to apply in the IPIFS for anything. But in case your trade secret is getting copied or infringed by some other person, then this law on trade secret give you right to go to the court and tell the court that my trade secret, which I have taken so much of care to protect it and keep it confidential, was copied by my employee or whoever, and then get a action or some relief from the court. So having a trade secret law helps in getting your right protected by the court in case your right is being infringed. But for trade secret, to prove that your trade secret is being infringed, there are steps which I'll go in later slides. Then, fourth, more very important concept is trademark. I'm sure all of you know about this because this is one of the most interesting, easy, and cheap IP that you get, and which has a highest award winning, property. Because trademark can be commercialized quickly and it doesn't require a lot of funding or money to go about it. Trademark, as the word represent, is a mark which is connected to your trade. So as I said, Ceylon tea, which comes from Ceylon. So that's a trademark. So anything which helps to distinguish your business from the rest part of the world or rest of the business can be registered under trademark. It can be a word, it can be symbol, it can be logo, it can be design, it can be slogan that basically identifies and distinguish your product or service from rest of your same group member. For example, Coca-Cola is a name. So under the Coca-Cola, this is interesting brand because Coca-Cola as a name is also registered. Coca-Cola as a bottle design is also registered. Coca-Cola as a liquid is protected as trade secret, and it is protected as copyright. The labeling, the way everything is written or designed on the bottle label is copyrighted. So Coca-Cola is a beautiful example of how IP is a bundle of right. IP is just not one right because you take example of any product. Take example of this small pen. The lead here is patented. The shape is design protected. The labeling, the company's name is trademark, and possibly there is something inside the technology which could have been long back a trade secret. So generally, if you see any product, you can have IP as a bundle of right. It is just not one IP, it is multiple IP, patent, trademark, copyright. The labeling or the way its cover page is done can be copyrighted. So Coca-Cola is a very interesting example of how a one product can have a bundle of different form of IP. And trademark is protected. This is called for trademark, the protection generally given by a country is 15 years, but with the condition that suppose your trademark continues to exist even after 15 years, then you have to pay some money, renewal money, in the IP office, and you can continue using that trademark as long as you want to. But every 10 or every 5 years, as per the local law, you need to renew your trademark by giving some money to the IP office. So trademark, it is called now, it's a renewable till your lifetime if you want. But most of the companies with the globalization nowadays like to innovate with their trademark a little bit here and there because once you are in a market for 15 years, if you have become a brand name, people tend to copy it some way or the other. Like in Nepal, when you travel to Nepal, you'll say, rock cola, bola bola, and in the same format as a Coca-Cola. Because Coca-Cola is so famous everywhere that it's easy for them to copy. So for Nepal as a country, Coca-Cola has innovated and did some minor changes in their branding and promotion as a tagline in Nepal. So every company, even if they registered, even in they keep innovating and renovating their IP because of the globalization and e-commerce, which is expanding every other day. So this is just an example of how IP is a bundle of right. Just you take an example of mobile. All student must be knowing more than me that how one particular brand, product can have different categories of IP. For example, mobile trademark could be Apple. Patent is the data processing method, semiconductor circuits. Trade secret, the way the slides when you move your hands how it works is a trade secret. And copyright, the software code which is being used here is protected as copyright. Design, obviously, I'm sure many of you might have read about the cases which Samsung and Apple had on the design of their mobile handset. So could be a multiple and a bundle of right. This is just to show that nowadays US always had IP in their constitution, and many country has IP in their constitution as a protection. For example, a country like Nepal also has mention of IP in their constitution. Sorry. So IP, most of the time we try and connect IP with real property, because just as real property is important for our personal growth and for personal security. Because why do we buy property? Because tomorrow we know if we need money, we can sell it off. Similarly, IP. Suppose I am a student, and today I come out with a very interesting, innovative paper, which is a write up for a big innovation which can happen by somebody, some technological person. But as me being a researcher, I don't know how to develop that concept into a technology. But what I do, that I protect my concept as copyright and then sell it or license it to the technology company. You might have heard Meta, Facebook, Google, they buy many startups to, become a bigger company. So all these startups, those who merge or which sell their innovative ideas to bigger companies, they don't sell it because they want to sell it. They sell it because they don't have capability, but they are using their IP. That is something when even if suppose today I come out with a brand of my own, so a textile brand of my own. I don't know how to use it in the market because I don't have funding. So what I do, my concept is very good. I have registered it legally with the IP office. I go to a big brand called Levi's or Adidas and I tell them, see, this is my concept. I have it registered, so nobody else can copy it. You can use my idea, but every profit or sale that you do in the market, you pay me the royalty. I have that kind of agreement with that company. So I'm using that my IP as a property, because that property is giving me money for the time being as long as I want. So that's why most of the time we compute intellectual property with the property rights. So IP is created out of somebody's mind. It's not only knowledge, but knowledge put into paper. And what is IPR? IPR is the right granted by the local authority. For example, intellectual property is something that you create, put it in a tangible form, but only when you file it with the IP office, legally register it, then you get IPR, IP rights. Why it's important to have IP? I have given you example, just briefly touch upon it, is that it gives you ownership. You are the owner of thing, you can sell it, license it. It gives you exclusivity once you have a product which you have registered. Once you have, suppose, a research paper that you are registered as copyright, it is your right. You are the first person who has devised that concept, who have written about that concept, which so you have the exclusivity whether you want to keep it to yourself or you want to share it with your senior, with the university, with the higher other universities, for them to use that to bring some kind of prototype or develop some kind of innovative product. So you get exclusive right on that. And then you can use that IP to permission to license for others to use it. The fourth important point, which I keep re-emphasizing on all my presentation, is that IP is a territorial right. It is very important because I have met and discussed with so many people that they forget. They just develop some kind of important concept, trademark, and they don't register it. First of all, once they register it, they sell their product in different part of the world and put it on the e-commerce platform without registering in different country. So if you don't, suppose you're putting on an e-commerce platform and you have not registered in other countries, your property is going to get copied if it is very important. Even if it is not important, it's very easy for somebody to copy a established brand in the market. So it is very important that you register in countries where you think your product have a market in place. This is again just revisit to the various example I gave. Apart from what IP I just spoke, there are a couple of more IP laws which is there in most of the country. One is called geographical indication. For example, Ceylon tea in Sri Lanka is an example of uh, IP which comes out originate from a particular geography of the country, which is called geographical indication. In India, I'm sure many of you know about Darjeeling tea. It's a tea which is coming from a particular region. You might have read about basmati rice, which is a controversial topic. A rice coming from Pakistan, India, Nepal. I think some more countries have also filed. So these are different type of intellectual property, which is called geographical indication. A property which comes out from a particular geography because of the different kind of soil, different kind of people, those who work in that geography. So unlike other IPR, which is trademark, copyright, patent, which is registered by an individual or a company, geographical indication right is a very different and interesting right because this is right given to a community. It can never be given to one person because any creation which comes out of a particular geography has to have been done by a lot of people sitting in that region or working in that agriculture space or creating that product. So it is called geographical indication, a product which indicate which part of the geography it is coming from. And it is not an individual right, it is a right given to a group of people who manufacture or produces that product or who cultivates that product, which has unique features. Apart from that, there is a Plant Varieties Act. Different kind of plant varieties also get protection under the Plant Varieties Act because under plant varieties, if you have, suppose we have a mango and you create some kind of new variety which gives another variety of mango which is unique, then you can register it under the plant varieties. The next is Semiconductor Chip Protection Act. Many countries have this act also where different chips that we use behind the laptop, computers, phone, that is also registered under this act. So IP, when register an IP, it is just not beneficial to the investors or creators who those who create, but it also gives a benefit to the society. For example, if you take example of any a product from Sri Lanka, for example, you have lots of gems and jewelries in Sri Lanka. So, and you as an innovator, you design, use the gems and jewelry which is available in Sri Lanka, and you design jewelries in a very unique design, and you start, selling it as a brand name under some interesting name registered in IP. So, what happens that I'm traveling from India to Sri Lanka, and I know that brand. For example, there is a brand called Love Sri Odell in Sri Lanka, Love Sri Lanka, or some brand. Whenever I travel to Sri Lanka, I do go and buy that product from Sri Lanka. And you won't believe that all my American colleagues who work with me, every time they go to Sri Lanka, they buy from Sri Lanka. Because the innovator, investor, creator, they created it, they protected it there. Now I go to that country, I buy it, so it is helping the society also and government also because I'm paying money and tax for that product. So IP just not helps the creator, it helps the ecosystem as a whole. It gives society a variety of products because if there are 4 or 5 researchers and all of you get into different areas, or even for example, if suppose there is a textile designer and 5 designers get into different 5 types of product, so as a consumer in this society, you have a competing market where you can bargain and get the best price. So as a society you are benefiting. At the same time, government is also having many products in the market which impacts the generation of revenue. You as a creator giving some revenue to government. Government is generating revenue by selling it across the world. I'm going as a tourist, buying it, giving some funding to the local government. So all this is linked. So IP is just not restricted to one person who creates it, but it's a circle which helps a society or a government as a whole. But when it comes to enforcement, generally when you go, suppose you have an IP right in your product and you want to enforce it, and there is somebody copying and you go to police or a custom, they would generally say, we will not take action unless you come forefront to us. So this is the concept that owners of proving their case or letting the enforcement official know that your IP is being infringed is generally on the stakeholder, those who have filed an IP. But now many countries have started giving power to customs, police, that they should also suo moto. Suo moto means that on their own should start taking action. So suppose in Sri Lanka, for example, because I work a lot with the Sri Lankan enforcement official, I know the consumer department in Sri Lanka have a right under the law to go and enforce, to research market and see if there is any adulterated, counterfeit pharmaceutical product in the market or any product in the market which is harmful for the consumer in any way. They can seize those products. So nowadays, government has become very conscious. Long back, 10 years back, they used to think IP is an individual's right. So government should not take an action unless individual comes and blame, complains to us. But now it's working other way because government has realized IP is just not for the individual, it is for the society as a whole. So a little bit of detail about all. As I mentioned, trademark can be anything: name, symbol, device that helps to identify your goods and services from the other goods and services. It can be anything. So once you apply for trademark in your country, you should always remember to write TM on the top, because TM, when you write TM on your name, which you have filed an application, that means you are letting the world know that you have applied for this registration and the registration is pending with the IP office. Once you get a registration by the IP office, you should start writing R on it. So now when you go to the market, start looking for the product that you buy. If it is written R, that means it's a legally registered product in the market. Many old product, they don't register also, they never registered. So products like Samsung, all those products which have been in market but were not registered in local market, like for example in Sri Lanka, those are called well-known products. So nowadays countries have started recognizing well-known trademarks. So if suppose I in India start copying Samsung and Samsung does not have a right, they can still file a case against me because it's a well-known mark in the country. So here, if you have this kind of, you as a researcher, you come out with some kind of innovative drink and you create your own drink without any trademark, it's very difficult to identify your product. So it is important to have, this is all the process. This is just an example. Starbucks is a registered trademark. It is, Nike, this sign you can, Nike word is also registered, Nike sign is also registered. And when you see Nike tick mark along with do it yourself, that in totality, that dress code is also registered. So trademark can be registered in various form. It can be color combination, it can be a shape of a product can also be registered. These are all called non-conventional trademark: sound, color, and smell. So if you have you all seen JF tire? No, what do you call that? Tires. There is a tire company. So their smell is also registered. If that tires goes on a track, you can feel a smell out of it. So you can register your sound and smell and color also of any product if you want to distinguish your product from rest of the product. These are some of the, I think I'm running behind schedule. How am I on time? How much time I have? These are some form of geographical indications. Darjeeling tea, champagne, apple, all those things. I'm sure you have learned about it. Patent I have already covered. So every time you come out with a product or an idea, you should always look for, if you say innovative product, you should always look for whether it's new, whether it was useful, and third, whether non-obvious, whether it is known to the world or it is new to the world. And as a researcher, which is very important for you, that if you're developing a paper, suppose if you're coming out with some very innovative, interesting concept, then before letting the world know that this is what I'm thinking, you should first register that as a copyright with the IP office. Though you will understand that copyright is a interesting right, because you don't need to register copyright with the IP office, because as soon as you develop that concept, you have a right in that work. But from the legal perspective, it's always important to file registration with the IP office, because even if it's your original creation and you write C under your work as copyright, that will not give you, injunction in court if you go for a file a case against somebody else. But if you have a legally registered it, at least you have a document, proof, and evidence that it is your first. It was you who thought about it first. So it is very important that if you're, writing a research paper and you think that tomorrow it is going to be a big development in the world, you should register it as a copyright. Even if you think it's not going to be a big thing in future, you should register, because filing fee for the copyright is very minimal. It's very like 500, 200, like that rupees. And when you file for an app patent, there are two steps. One is called provisional. This is just, I'm just briefly touching upon it because it is important, that when you come out with some kind of innovation which is new, non-obvious, and industry, which has an industrial application, but now, right now, you don't know whether it is going to have an industrial application or not, but you have already developed the idea and you don't want others to copy it. So what you do, you file a provisional application with the IP office. So once you file a provisional application, that contains very basic brief about your product or process, and after that you get 18 months to develop your idea into a proper product or prototype. So that is given by the law, that you have 18 months to develop your prototype and then go for the non-provisional and the complete specification of the product. So if you have conceived some idea in paper, you should first go ahead and go and apply for a provisional application, and then take 18 months time to develop that as a product and do the testing and R&D that you want to do on it. So this helps you from getting copied by some other person. Trade secret, I think I should skip because it's already. How much time do I have?
Ms. Shilpi, we can go about another 10 minutes or 5 minutes.
Okay. So trade secret, as I said, there is no application for this, but when you have a trade secret violation, that you need to show to the court that how how much effort you had put in to keep that secret as your trade secret. And there many times there is a question that people ask us, that why would not I wait for trade secret and not go for patent? So generally, there are few innovation which has a short life. So for those kind of innovation, people go for filing patent, because after 20 years it goes to the public domain. But there are some kind of trade secrets which can exist forever. Like Coca-Cola is not going anywhere. That is a secret recipe. So if they had filed patent for that process of their recipe, that would have died in 20 years. But now they can keep it for eternity. So there are factors that decides whether you should go for trade secret or you should file a patent application. These are different areas where you can have copyright protection. As I said, this is again IP as a bundle of right. Every product can have multiple IP associated with. For example, this I had taken from one of the Japanese presenter. So I have written in this case slide presented by Yuji Okama, just to show that the presentation that I gave you today is my presentation. This is my creation. But this part of the presentation I took from his presentation. So I have put a disclaimer here telling that, this was taken from his presentation. So this way I'm not violating his copyright. Okay, so that was a basic brief about the IPR. And now these are, I have left few resources in my presentation, which I'll share with Januka if you all want, just to see if you are interested in knowing more about IP, because IP is very technical. And one, our presentation is not enough, because There are multiple areas which keeps your mind involved. So these are few research or some papers which is very good on the website, on USPTO website, which you should go and as a researchers go and read and find more about it, like how you can become an entrepreneur, what you should do as a IP holder, how to identify your IP, and what once you have identified your IP, what is your next step you should take. And these are some inventors assistance centers. So suppose you are an inventor and you want to file a IP in US, so you can talk to these people and find out what is the process, how I should go about it, and what are the forms I should fill. Anything you want, you can find out here. Similarly, this is a trademark assistance center, patent resource, USP2 patent pro bono program. This is very helpful program. I have had personal experience with this. They pro bono, these are network of lawyers who help you to find out whether your IP can be registered in US or not. It is all free of service. These are again all free of service. This gives you a training, also gives you certificate, all those things. This is StopFake.gov. You can go here and see how counterfeiting happens. What are the steps you should take to protect your IP from being counterfeited? What are the careers with the USPTO? How you can apply for USPTO job? What qualification you would require? That's it. I think I have covered in 5 minutes. That's it from my side, Janika. You can.
I have one question.
Over to you.
I have one question.
Yes.
Generally, as a researchers, we publish in index journals or conferences. Then after
Right.
publishing it, then can we go for copyright?
See, once you publish it, no, even if it's given to public, but you should always write under your document under a disclaimer that the copyright is with whom, with the university, with the individual name, and then you can always register it, because it is, as I said, for copyright you don't need to legally register it, because as soon as you come out with the concept note that IP is for you. But when it comes to filing a case, if somebody copies your idea, it becomes very difficult for you to prove your case if you don't have a registered document in your name. So even if you have published it, it is important that you file an application in the Copyright Office so that you have a legal document to prove it, that that's your original idea. But if you are not filing it, always remember to write the person's name and write, see, if you read the books, you will see there's written copyright at the rate of university's name or individual name or the publisher's name. It's very important, and write the year when it was published, month, year, everything. And keep the documentation properly. But as a lawyer, it is advised in the present scenario where things are going, everything on the e-commerce platform, its globalization is going on, you should always file an application in IP office, and cost for filing copyright is very minimal in all offices all across the world. It is affordable by students also.
Okay,
and I think every university, I think in Sri Lanka, I have worked with 14 universities to develop their IP policy. So every universities have their own IP cell, I believe. So they help for you also as a university. It is deliverables to show that how many IP was filed from your university, and keep a documentation of all IP files.
Okay, the session is open for other questions. So if you have any questions, you can ask. Yeah.
Thank you for your insightful session. I have a question. What legal risk should students aware of when we using open source resources as a part of our projects?
See, if you're using open source as a part of your research, you should always, write as a disclaimer that this part of the research was taken from this open source. Because as I was giving example today, suppose what the presentation that I gave you, if I share with you, so you can also create a presentation out of my presentation But wherever you're using my slide, you should give a disclaimer that this part of this slide was taken from Shilpi Jha so and so. And suppose if you're using the research paper that you are creating using an open source for commercialization, so nowadays everywhere, if you have to take a permission from that place, for open source, of course, you don't need a permission. You just need to mention that this part was taken from that open source. That's it, that disclaimer. But if suppose you are taking some information from my publication, then you should take permission from me, provided your work is going to be in public domain, because you will be earning out of my work, which you are putting as your work, as a part of your work.
Thank you.
I hope I was able to answer your question.
Yes, madam. Thank you.
Okay.
Okay, Ms. Shilpi, I think we can formally conclude our session. First and foremost,
Okay.
thank you very much for accepting our invitation beside your busy schedule and investing your time and effort on our students. Thank you very much, and it's been a very insightful session. I think it is, much needed session at this moment. So thank you very much, and we will collaborate with you in the future as well. So thank you.
Thank you. Thank you, everybody, for joining, those who joined today. And thank you, University, because this is a very important topic. So good that you're having a series of discussions on these kind of issues. Thanks a lot for inviting me.